If your last name is Vallejo, Castro, or listen closely, a document exists with your family's name on it. It sits in a courthouse archive today. It once decided whether you kept your own land. In 1848, the United States signed a treaty. It promised to protect the land of every Mexican family living in California. 2 years later, it changed its mind. It made every single one of them prove that promise in court or lose everything. Most lost not to Mexico, not to war, to American lawyers, American courts, and a law with a boring, forgettable name, the California Land Act of 1851. Here's your first name on that list. Take the family first. If you're from Orange County, you already know this ground. Rancho Santiago was granted in 1810. It covered roughly what is now Orange and Tustin. Alone held tens of thousands of acres of it. So did win his case? Yes, the claim was confirmed, but confirmed did not mean he kept it whole. Survey costs came next, then subdivision, then decades of lawsuits between his own heirs, cutting the rancho apart before it ever reached his whole. Winning in court and keeping the land turned out to be two different things. You just watched that promise fail once. Here is the sentence it was supposed to guarantee. Article 8 of the treaty is one line. Property belonging to Mexican citizens would be, quote, inviolably respected. One sentence. That was the deal that ended the war with Mexico. Then gold turned up at Sutter's Mill. 150,000 strangers arrived in 2 years. Every one of them wanted land that already had a family's name attached to it. Whose name would you rather believe if you were a judge in 1852 in a courtroom full of new voters? Congress answered with a second law. Picture it as your own 2-year deadline. Every rancho owner in California had 2 years to walk into a federal land commission. They had to prove with documents that their own government's grant was real. Miss your deadline and the land became public domain. No trial required. Winning at the commission wasn't winning. The government's own lawyer could appeal automatically, straight to a federal district court, from there often straight to the Supreme Court. Historians who studied the whole process put the average case at roughly 17 years, filing to final title. Could your family have survived 17 years of legal bills, with no income from the land the whole time? 17 years of filing fees, surveyors, and attorneys, in a territory where cash was scarce. Land was the only thing a rancho family actually owned, so that is exactly how many of them paid, in acres, one parcel at a time. Would you have any land left after paying a lawyer in dirt for 17 straight years? Next, the family. If you have ever driven Verdes Drive, you have driven their old rancho. They held those cliffs above the Pacific, south of Los Angeles. Their boundary overlapped a neighboring grant, the rancho next door. That overlap alone became its own separate lawsuit, stacked on top of the 17-year clock already running. Did they win their boundary fight? Eventually, yes, on paper. But in practice, the family sold off pieces of Verdes for decades afterward, just to cover the legal costs of proving they had owned it in the first place. What is left in family hands today is a fraction of the original grant. Now the biggest one on this list. Received Rancho San in 1820. It was enormous. Nearly the entire footprint of today's Oakland, Berkeley, Alameda, and Piedmont. If you have ever lived in the East Bay, you have lived on it. All one family's name on one piece of paper. Do you know how long that took to settle? 25 years, filed to finally, legally closed. Squatters built houses on the land while the case was still open. American courts were reluctant to evict people who had already been living there for years by the time a judge finally ruled. By the time the paperwork closed, almost none of Rancho San was still land. Every street sign in modern Oakland traces back to a family that legally won its case and still lost the land. Have you ever wondered whose name was on your street before it had a street name at all? Vallejo wasn't a bystander in any of this. This is where the story gets harder for you to explain away. He was the most powerful in the North. He held vast grants, including Rancho Petaluma. He actually welcomed American statehood, believing it would protect his people better than Mexico ever had. So if loyalty to the new government was supposed to buy you anything, wouldn't it have bought Vallejo something? It didn't. He spent the rest of his life and most of his fortune defending his own titles in the same courts he had personally trusted. He kept his name in California history. He did not keep the land. Here's the one nobody expects, and you should sit with this one. It belongs at the very end of this list for a reason. Was the last Mexican governor of California. Before the war, he personally controlled several ranchos, including Rancho Margarita, one of the single largest grants in the entire territory. If a rancho family's own governor couldn't keep his land, what real chance did an ordinary family actually have? Went through the same commission, the same appeals. The same 17-year clock as everyone else on this list. He still ended up losing almost everything to debt, fraud, and legal costs he could never fully outrun. He died in Los Angeles in 1894, in a modest room, in a city that now sits on land he once had the legal power to grant to anyone he chose. If the treaty could not even protect the governor's own land, what chance did your family's name actually have on that same list? One more name before the pattern is clear. The family held several ranchos around Barbara and San. If your family ever told you they came from old nobility, this is the kind of name they meant. Did they keep their titles? Mostly, eventually, yes, but not the land under them. Parcel by parcel, rancho by rancho, the family sold pieces off across 2 generations just to keep the rest out of a courtroom for 1 more year. Ask yourself, how many years of your own income would you spend defending land you already legally owned? So if your own family name was on this list, here's the pattern you would actually find. Historians who tallied every case filed under the 1851 Act found something the treaty never promised. Most claims were eventually confirmed, on paper, somewhere around 3 out of every 4. So why does almost none of that land remain in the original families today? Because the land wasn't mostly lost in court. It was lost paying for the right to be in court at all, for close to 2 decades, against a government that had signed a 1-sentence promise, then spent 17 years making that promise as expensive as possible to actually collect on. So here is what actually matters for you right now tonight. Your family's case file, if there is one, was not destroyed after the ruling came down. It was kept. Most of them have since been digitized. The library at UC Berkeley holds the original land case files. A large share is already scanned and searchable online through, completely free. The National Archives holds the district court dockets that came after. Search your own surname there tonight. See what your family's own case file actually says. If your family has an old story about land that was simply lost after the Americans arrived, this is very likely the real document trail behind that story. Not a family legend, softened with each generation, a case number, a filing date, a ruling, sitting in an archive most people never think to actually open. It's worth being specific about how to actually search, because these archives are not always built for a casual visitor. Start with the surname alone, not the rancho name. Land case files are indexed mostly by the claimant's name, not by the property, so the family name is your real entry point. Search the name, not the rancho. If nothing comes up under the exact spelling on your family tree, try the Spanish spelling and the anglicized version side by side. Clerks in the 1850s were not consistent, and a single family sometimes appears under 2 or 3 different spellings across different documents in the very same case file. Zoom out for a second, because this wasn't 5 unlucky families. There were over 800 private land claims filed under the 1851 Act, covering nearly 9 million acres of California. Almost all of that land belonged to Mexican and families the year before the act passed. 9 million acres is not a rounding error. That is roughly the size of the entire state of New Jersey. Try to picture a state that size changing hands, family by family, one exhausting legal case at a time, and ask yourself how a single treaty sentence was ever supposed to hold that back. That is really what this video is about. The treaty wasn't broken all at once, in one dramatic moment. It was broken 800 times, quietly, one case number at a time, over nearly 3 decades, until almost nobody was left to notice the pattern. So was this deliberate or just a badly written law? Historians still argue about that, and you should hear both sides before you decide for yourself. The law itself didn't say take the land. On paper, it only asked for proof, the same proof any government might reasonably ask for. But a 2-year filing deadline, an automatic government appeal, and a 17-year average timeline weren't neutral. They were a machine that quietly favored whoever could afford to wait the longest. Do you think that difference actually matters if the outcome looked the same either way? You might assume this all wrapped up quietly once the 19th century ended, but the last of these cases weren't fully closed until decades into the 20th. Some heirs were still litigating boundary lines their great-grandparents had first filed on, arguing over surveys nobody alive had actually witnessed being drawn. 70 years, 2 full generations, born and raised, without ever knowing a year when their family's land wasn't technically still in dispute somewhere in a federal court. What would that actually do to a family, growing up never fully certain the ground under the house was legally theirs? Every family on this list did exactly what the treaty told them to do, exactly what you would have done. They filed, they hired lawyers, they waited years for an answer. Some of them won on paper in front of a federal judge, exactly the way the law said they should. And they still lost the land anyway, not because the law found them lying about their own grant, because the law never once promised the land would still be affordable to keep, not by the time a ruling finally arrived 17 years later. Tell me in the comments if you searched tonight and what case number comes up under your own family name. And if you want another story about a single document deciding a family's entire fate, the Cherokee Dawes Rolls video on this channel is exactly that. A different government, a different century, the same kind of paper trail.